Hi, I'm Gary Smith, the business attorney with Venn Law Group in Charlotte, North Carolina. Now, let's say you open your mail one day and you find a letter from a customer, and they're demanding that you reimburse them for something that they did wrong. You toss it, you assume it's a mistake. But a week later, you get a letter from their lawyer. That same day, you're served with a lawsuit from someone you've never even worked with. What's going on? This is indemnification. And if you don't understand it, it can cost your business big. All right, let's break down what's involved. Your customer was sued by someone else. Let's call them the end user. Your customer settled that lawsuit, and then they turned around and said you owe them the money they paid out. Now, why? Because somewhere in a contract, you agreed to indemnify them. Indemnification is when you agree to take responsibility for someone else's losses, liabilities, legal costs, even if the problem wasn't directly your fault. You could be agreeing to hold them harmless, meaning you're covering everything, reimburse them for what they've paid, defend them so they don't have to do that. It can apply to lawsuits, settlements, judgments, even attorney's fees. In fact, it can apply to any and every type of expense or obligation. Sometimes indemnification is fair. You made a mistake, it caused harm. Other times you're on the hook simply because you signed a contract without understanding what you agreed to. This week I had a client get a contract where it says you're not only liable for what you do, you're liable for what anybody in the chain of whatever it is being manufactured did. You're responsible for doing product testing on the things that you buy. Now, my client just buys parts from manufacturers all over the world and sells them to its customer. It's going to do product testing. It's got to do audits on all of its vendors. And if it doesn't and there's an issue, they have to cover everything that the customer's paid. Now, most businesses treat indemnity clauses as boilerplate. They don't negotiate them, and that's a mistake. Let's say the contract says you'll indemnify your customer for any claim arising out of or related to your products or services, similar to something my client was being asked to sign. It doesn't say it has to be your fault. It's just somehow related to something you did. That could mean an end user misuses your product, but you're liable. The customer might have modified your product, but you still pay. Even someone else is at fault, but you agreed to cover that cost contractually. Worse, your insurance might not cover the claim. Now you're paying out of pocket. Now, surely that doesn't happen. A court wouldn't say that's okay, would it? It would. Businesses are considered to know what they're doing. They aren't seen as needing protection from other businesses like consumers are. Courts enforce the deal you made. When you see an indemnification clause, read it carefully. Who are you indemnifying and for what? You need to limit the scope. Negotiate to cover only issues you actually control and damages you actually caused. Now, also watch out for the duty to defend. That could mean paying for their lawyers and settlements they make too that you don't know about. Check your insurance. Make sure it covers the risks that you're accepting. And check your contracts. Make sure what protections you have from your vendors. And most importantly, don't sign indemnity clauses blindly. What seems like a small detail can turn into a big liability. Indemnification isn't just legal fine print, it's a risk transfer. And if you don't understand what you've agreed to, it could come back to bite you. At Venn Law Group, we help businesses review and negotiate contracts before they turn into lawsuits. Need help reviewing indemnification clauses? Please contact us at Venn Law Group.